Welcome, everyone, wherever you may be, in whichever time zone, as this is a world event. I am thrilled to introduce this second symposium on reparations under international law for enslavement of Africans in the Americas and the Caribbean. This symposium is a partnership of the American Society of International Law with the University of West Indies Center for Reparation Research. Let me first thank our symposium chair, the Honorable Judge Patrick L. Robinson, esteemed member of the International Court of Justice, and immediate past honorary president of our society. I also would like to thank the brilliant scholars and colleagues who worked on the advisory committee for the symposium, consisting of Professor Vereen Shepherd of the University of West Indies, David Eltis Woodruss Professor Emeritus of History at Emory, Professor Robert Beckford of the University of Winchester, and Ms. Priscilla Robinson of Queen's Court Chambers in London. Together with my wonderful colleagues in the Society, Natalie Reed, co-chair of Debevoise and Plimpton's Public International Law Group, and Chantal Thomas of Cornell University Law School, as their role as organizers of this symposium. The impressive first symposium held last May addressed such critical issues as the historical and the social context of transatlantic chattel slavery, its legality or illegality under international law at the time that it took place, and the economic basis for the assessment of reparations. Through it, participants built the case for the illegality of transatlantic chattel slavery under international law. This second symposium builds from the first by bringing together international law scholars and jurists, historians, and economists to address the issue of reparations. As we will see, such reparations can take the form of monetary compensation or satisfaction. The first symposium's proceedings are freely available on our website and can be downloaded as an ebook. One can also freely view the video of the symposium from the website. This symposium is generative, dynamic, and intellectually rigorous. It builds on a legacy of robust scholarship on legal questions related to accountability, repair, and moral commitments, post-colonialism, and slavery. These matters touch my family's life and are personal to me. The legacy of American slavery, etched through Mississippi, is a legacy that my formidable wife, the renowned author, activist, and public intellectual, Michelle Goodwin, inherited. We know much too well the cruelties that Mississippi, the most notorious state in the United States for brutality against Black Americans, inflicted on them both before and after slavery formally ended. Such horrors were made legal by way of sundown laws, Black codes, racial covenants, quote, separate but equal restrictions, and coercive contracts on their labor. We bear witness to this. Yet regardless of one's birth or immediate family connections, the legacy of slavery touches all of us. Its reach extends today in racial discrimination across areas of social life, from our healthcare systems to the carceral state, from movements to suppress democracy, to resistance to teaching about our racial history, and thus any reckoning with our past. As William Faulkner wrote, the past is never dead. It is not even past. At ASIL, our governing mission is to convene people to study and assess international law, to examine our past, and to build a better present and future in which international relations are established and maintained on the basis of law and justice. We cannot and we do not segregate our moral concerns, to quote the civil rights leader, Dr. Martin Luther King Jr. Let me now introduce our partner in this project, Dr. Vereen Shepherd, Director of the University of the West Indies Center for Reparation Research. Dr. Shepherd is a world-renowned historian and one of the Caribbean's preeminent scholars and advocates for gender justice, racial equality, and non-discrimination, and reparation for the impact of European colonization on Indigenous peoples, Africans, and people of African and Asian descent. Dr. Shepherd received her master's and her BA at the University of the West Indies and her doctorate at the University of Cambridge in the United Kingdom. She is a path-breaking individual. Among her many firsts, she is the first Jamaican and CARICOM citizen to be elected to the United Nations Committee on the Elimination of Racial Discrimination, of which she now serves as vice chair. She is currently one of the 3 vice chairs of the CARICOM Reparations Commission, and she has served as chair and co-chair of the Jamaican National Commission on Reparations. Professor Shepherd, it is my honor to turn this second symposium over to you.
Thank you very much. Let me greet His Excellency Patrick Robinson, Judge of the International Court of Justice. And of course, as you have heard, Honorary President of the American Society of International Law, ASIL. I greet Professor Sir Hilary Beckles, Vice Chancellor of the University of the West Indies, which turns 75 this year. ASIL President, Professor Gregory Schaefer, Ms. Natalie Reid, Ms. Chantal Thomas, and other ASIL members of the Battle Group, other presenters, and the discussants, and our distinguished audience. Good morning to everyone. On behalf of the Center for Reparation Research, let me say how pleased I am to be involved yet again in a collaborative symposium between ASIL and the University of the West Indies, a collaboration initiated by its Honorary President, Judge Robinson, who in 2020, as the Honorary President of ASIL, proposed that the Society should convene an international symposium to debate the question of the lawfulness or illegality of transatlantic chattel slavery and collaborate with the University of the West Indies, the UWI. This second international symposium on the quantification of reparations for transatlantic chattel slavery, TCS, is timely, reflective as it does of the current state of scholarly and general public interest and research on the transatlantic trafficking of captured Africans, their chattelization in the West, and the need for acknowledging and repairing the resultant harms whose legacies are everywhere still to be seen. The UWI is a fitting partner in the second symposium, as with the first, of course, because it has a long tradition of researching the history of the transatlantic trafficking in Africans and the chattel enslavement of Africans through its history departments, its internationally known historians, and other scholars working on decolonization and decolonial justice. Educational institutions, especially universities, that believe in decolonial justice are so important. And the UWI has a social justice agenda in its teaching and learning processes and in the production of students and staff who would be scholar activists, even in the late historian Walter Rodney's formulation, guerrilla, or some would say maroon intellectuals. It was that strategic imperative demonstrated in teaching and learning at the UWI after its establishment in 1948, which identified it as a university engaged in education for transformation of a people grappling with the diseases of colonialism and its continuing legacies. Historians in particular used their scholarship to critique narratives that needed to be critiqued, created new knowledge, and addressed myths and stereotypes that fed discrimination. In the final analysis, only a history that reverses centuries of myths and stereotypes can restore pride and dignity to Africans and people of African descent. Not surprisingly, the Vice Chancellor detailed the CRR, the Center for Reparations Research, to be the implementing arm of this collaboration. And we're very happy to be doing so again. And in my case, especially honored to have been asked to serve on Judge Robinson's advisory committee, providing guidance to his student researchers and content for him and the Brattle Group. No calculation or quantification of the reparation for this crime against humanity can be done with only lawyers and financial scientists. Economic, social, demographic, and quantitative historians are key to that process. And we have been honored to have made our contribution, suggesting experts and sources. I look forward to hearing the outcome of the work done so far. And of course, looking forward to how we will together bring reparation to people who are demanding it. And this work will contribute to removing any lingering misgivings that the transatlantic trafficking in Africans and the chattelization of our people were not crimes against humanity. For how can the genocide perpetrated over centuries, as shown by so many of our historians locally and internationally, not be a crime against humanity? The findings today will contribute to the global reparation movement and to the body of knowledge already generated by scholars, which will arm us for the battle ahead, in which the Brattle Group will continue to be key. So welcome to everyone on behalf of the Center for Reparations Research and the University of the West Indies. And we look forward to the revelations and the discussions that will emanate from these 2 days, revelations that will build on the work already done by others. For the debt has not yet been paid, the account has not been settled, as that reparation warrior, Dudley Thompson, famously said. Thank you very much.
Thank you very much, Professor Shepherd, and good morning, good afternoon, and good evening, everyone. My name is Natalie Reed. I have the pleasure and privilege of serving as one of the organizers for both the first and this second symposium on reparations under international law. I also have the honor of providing a very brief introduction to a gentleman who needs very little introduction at all, Judge Patrick Lipton Robinson, who is a member of the International Court of Justice, and I believe we shall now give you the title, sir, of Honorary President Emeritus of the American Society of International Law. As you have heard from our colleagues and previous speakers, Judge Robinson has been the driving force, both as a matter of personal and academic passion, but also, of course, as a thought leader in this project. Judge Robinson has dedicated literally decades of his life to public service, first on behalf of the people of Jamaica, and now as a leading member of the international community with decades of judicial service at the highest level. We will begin hearing from Judge Robinson this morning with opening remarks, and then he will again grace us with a discussion later on this morning in laying out the legal framework that has given the shape for the project undertaken for purposes of this second symposium. Judge Robinson, you have the floor.
Thank you very much, Natalie. I'd like to reiterate the warm welcome extended to all of you by Professor Vereen Shepherd. The International Symposium is streamed to all parts of the world, and wherever you are, please accept my gratitude for your interest. Ladies and gentlemen, it is right that the eyes of the world should be focused on this symposium because the question of reparations for transatlantic chattel slavery, which I will call TCS hereafter, affects not only the descendants of enslaved Africans and the European countries which engaged in this sordid and grotesque practice for well over 450 years. The chattelization of Africans impacts our common humanity and obliges us to put in place a system for the payment of reparations to the descendants of the enslaved in accordance with international law. As you know, the International Symposium that was held in 2021 concluded that on the basis of the law at that time, TCS was unlawful. As a result of this finding, international law now requires the payment of full reparations for the wrongful conduct involved in carrying out TCS. Consequently, there is an international obligation on the United Kingdom, France, Portugal, Spain, the Netherlands, Sweden, Denmark, and the United States of America to make full reparations to the descendants of those Africans whom they enslaved. But, ladies and gentlemen, it cannot be left to those former slaveholding states to determine the reparations that are to be paid. To do so would be to allow the wrongdoing state to determine the sum due for reparations, and thus, in a real sense, to perpetuate the mistreatment of the enslaved Africans and their descendants. In my own country, Jamaica, there are situations in which a worker may do a small job for a person, which does not call for the payment of a large sum of money. When that person asks the worker the cost of the job, the worker will say, "Give me your money," meaning that since the sum is small, it is left to the discretion of that person to determine how much is to be paid to the worker. Ladies and gentlemen, I make it plain that reparations are not about former slave-holding countries giving money to the descendants of the enslaved Africans. There must be a system whereby full reparations are determined in accordance with international law. This symposium on the quantification of reparations will provide such a system. It will produce a table which names all the countries in which TCS was carried out. And it will set out the reparations that are to be paid by a particular former slaveholding state to the descendants of the enslaved in those countries. The symposium is fortunate to have the services of a highly recognized and distinguished group of evaluators, the Brattle Group. They have placed a value on the several injuries or harms caused by TCS. This table is global in that it covers transatlantic chattel slavery in all the countries in which it was carried out, whether in the Caribbean, in Central America, in South America, or in North America. It is global and not parochial because we who are descendants of the enslaved all came to these parts on the same boat. Ladies and gentlemen, since the damage caused by TCS will not be made good by restitution and compensation, the law requires that what it calls satisfaction must be given. The International Law Commission tells us that satisfaction may take the form of an expression of regret, a formal apology, or some other appropriate modality. In my view, in the case of TCS, satisfaction is as important as, or even more important than, compensation. Much of the harm resulting from TCS cannot be remedied by cash payments. Perhaps the greatest harm caused by TCS is the psychological damage that it visited on enslaved Africans and their descendants. I now wish to say a few words about two important developments that have taken place since the first symposium. On the 19th of December 2022, the Dutch Prime Minister gave what can only be described as a full apology for his country's involvement in TCS. He described it as a crime against humanity and characterized his country's role in TCS as downright shameful. He commented on the administrative system that was set up by the Dutch to conduct TCS and noted that when practice was abolished in 1863, it was not the enslaved Africans who received compensation, but the slave owners. But for me, perhaps his most consequential statement was that he had for long been of the view that his country could not take responsibility for something that had happened so long ago. But he now acknowledged that his country does have responsibility for the suffering inflicted upon the enslaved and their descendants. Consequently for him, and I quote him, the Dutch cannot ignore the effects of the past and the present. End of quotation. Acknowledging that the Dutch state profited from TCS, he promised that his apology was not a full stop, but a comma. Ladies and gentlemen, in describing slavery as a crime against humanity, the Dutch Prime Minister echoed a similar assertion contained in the 2001 Durban Declaration at the World Conference Against Racism. That declaration stated that slavery and the slave trade are a crime against humanity and should always have been so. The concept of crimes against humanity, as you know, emerged out of the Second World War in relation to Germany's treatment of its Jewish citizens. TCS lasted from mid-15th century onto the latter part of the 19th century. Now, of course, norm-creating principles of humanity have existed from time immemorial. Indeed, the International Court of Justice itself spoke of what it called the elementary considerations of humanity, even more exacting in peace than in war. This was in its Corfu Channel judgment. And the 1815 Vienna Declaration on the abolition of the slave trade recognized that, here I quote, the slave trade has been considered by just and enlightened men of all ages as repugnant to the principles of humanity and morality, end of quote. There is therefore a legal foundation for the Durban Declaration statement that TCS is and should always have been a crime against humanity. And for that reason, there is justification for what appears to be the Dutch Prime Minister's embrace of that declaration. Ladies and gentlemen, while the Dutch apology is not opposable to other former slaveholding states, it is beyond question that every statement made by the Prime Minister is equally true of the United Kingdom, of France, of Spain, of Portugal, and the other former slaveholding states. There is indeed a parallelism between the Dutch and the United Kingdom, in the same way that the Dutch, as acknowledged by the Prime Minister, set up slave trading bodies, so did Britain. In the same way that the Dutch, as acknowledged by the Prime Minister, compensated slave owners, but did not compensate the enslaved, so did Britain. For years, the traditional response of the United Kingdom to claims of reparations has been that TCS happened a long time ago, and the descendants should not look back but forward, and in any event, TCS was lawful conduct. But in light of the Dutch apology, how can the United Kingdom and other former slaveholding states ignore what the Dutch Prime Minister calls the effects of the past on the present and continue to argue that TCS was lawful? It will be observed that there is a difference between the International Law Commission's articles on state responsibility and the Dutch in the treatment of an apology. In the former, an apology is a form of satisfaction that is required when restitution and compensation do not make good the damage or harm resulting from wrongful conduct. In that sequence, the apology, which postdates the wrongful conduct, is an acknowledgement of that conduct. However, in the Prime Minister's statement, the apology has come first, to be followed by compensation if the comma, not full stop imagery used by the Prime Minister means anything. In this sequence, there is also the implication that TCS was unlawful conduct, particularly in light of the chronicling by the Prime Minister of a myriad of acts: branding the faces of the enslaved with hot irons, hacking off their limbs, and torturing, that he clearly viewed as unlawful. Ladies and gentlemen, I now invite the Dutch to write a full stop by making reparations on the basis set out in the table produced by the Symposium. I turn now to the second development, and that was the decision of the Church of England to commit £100 million to a fund to compensate for its historical benefit from TCS. Part of the origins of the Church of England's Perpetual Endowment Fund is the Queen Anne's Bounty, founded in 1704. The bounty invested in assets linked to the South Sea Company, itself founded in 1711 to trade in transatlantic chattel slavery. Ladies and gentlemen, although this Church of England initiative may be well intentioned, in my view, it presents all the problems of a reparation scheme which is crafted entirely by the wrongdoers or those representing them. The report shows that the Church of England, through the Queen Anne's bounty, had annuities and investments in the South Sea Company in the excess of 1.5 million pounds, which is equivalent to 1.4 billion pounds in today's money. It is therefore clear that when the Anglican Church sets aside 100 million pounds for the benefit of the descendants of the enslaved, a figure that is less than 1% of the income it derived from TCS, it was merely, in Jamaican parlance, giving them a money, which is not how a scheme for reparations should operate. I trust that in avoiding the term reparations to describe the projects it is undertaking, the Church is not shying away from this term because it would suggest that TCS was wrongful conduct. The report does show the Church to be highly critical of TCS, describing it as a shameful and horrific sin. I would hope that there is no doubt in the mind of the Church of England that TCS was an unlawful practice and that the work that it is now undertaking constitutes reparations for that practice. Ladies and gentlemen, I will now tell you briefly about the program for the symposium. Today, we will hear from Sir Hilary Beckles, Vice Chancellor of the University of the West Indies, which, as you have heard, in collaboration with the American Society of International Law, has convened the symposium. Sir Hilary will give the keynote address. I will make a presentation on the legal framework for reparations for TCS. Thereafter, the Brattle Group of evaluators will present their report on the quantification of reparations. And this will be followed by a group of discussants who will comment on the Brattle report. On Friday, that's tomorrow, the symposium will continue with another group of discussants reacting to the report. I thank you. Those are my opening remarks. The next speaker, as I just indicated, is Sir Hilary Beckles. Professor Sir Hilary Beckles is the 8th Vice Chancellor of the University of the West Indies. He's a distinguished academic, international thought leader, United Nations committee official, and global public activist in the field of social justice. He received his higher education in the United Kingdom and is professor of economic history. He has published well over 100 peer-reviewed essays in scholarly journals and over 13 books on subjects ranging from Atlantic and Caribbean history, gender relations in the Caribbean, sport development, and popular culture. Sir Hilary is president of Universities Caribbean, chairman of the Caribbean Examinations Council, and chairman of the CARICOM Reparations Commission. Sir Hilary, you now have the floor. Thank you.
Judge Robinson, Sir Hilary hasn't joined the Zoom yet.
So we will wait for him to join. He's expected to join. No?
We are currently running about 15 minutes early, which is a little bit
I see, I
unusual.
see.
But I have alerted Sir Hilary's staff that we are ready for him ahead of schedule. So we'll hope that he will join as soon as possible.
Well, we will just exercise some patience. You remember, we were told when we were young that patience is a virtue.
And we will hope to be exceedingly virtuous, sir.
Okay.
In the interim, while we wait for Sir Hilary to join, just an organizational note. That for anyone who is watching, as we did for the first symposium, short biographical blurbs of all of the speakers are available from the webpage on which this is being streamed. And at the end of the symposium, the formal report prepared by the Brattle team will be available for download and reviewing. I see that Sir Hilary has joined us. Thank you very much, sir. We are unusually ahead of schedule, so we are grateful that you can join us, even though we are starting a little bit earlier. Welcome back to the symposium, sir.
Sir Hilary, I just gave you the floor in your absence, and I give you the floor again. Thank you very much.
Okay, well, thank you. Thank you all for this invitation to participate in your conference proceedings. I will make a broad-based contribution. I note that your primary interest is in the legal framework and also financial calculations surrounding what reparatory justice models can look like, and that is all fine. And I think this is very important work indeed. It's a broad-based conversation, negotiation, as you are aware. My focus in the last year or two has been in the diplomacy end of the movement, seeking to broaden the participatory engagements of around the world, because we are in effect building out a global movement. So I will speak for a short while about that process, and then I will comment on the CARICOM development model, which has at its center the reparatory justice process. In CARICOM and the Reparations Commission, we took a decision that the engagement of African governments in the movement, joining forces with diaspora governments and NGOs and other organizations, will be a game changer in terms of generating global attention. The argument was made that so long as diaspora communities in CARICOM, primarily, and in the USA, civil society movements, as long as that remains the core of the advocacy, that it would be no fundamental challenge for those states that committed these crimes against humanity to set aside the representations from the diaspora. In CARICOM, for example, letters were written government to government across the European Union to invite them to a summit to discuss this matter. Their position was that they acknowledged that the Caribbean and the diaspora Black community had suffered, but they were not prepared to come to a reparations summit, that their preference would be to allocate financial resources by way of foreign aid. Many people, of course, believe that that was an embarrassing response. So we have been focusing on building a bridge between CARICOM and the African states. And a tremendous amount of effort went into having negotiations with African governments. And we felt that we have made some very significant progress, because in August of 2022, a summit was held in Ghana and Accra. And the keynote was presented by the president of Ghana, President Addo, who announced that it is now the policy of the African Union to support the CARICOM diaspora reparations movement, and that going forward, CARICOM and the African Union will be speaking with one voice on the matter of reparations. This was a major breakthrough. The Prime Minister of Barbados had been in deep advocacy with President Addo and other African leaders. So it is a significant triumph that the African Union is now joining the Caribbean Union to speak as one voice. And in May of this year, there is going to be a major summit in Kenya, because the Kenyan government has declared an interest in hosting an African Union meeting on the issue of reparatory justice. And there are going to be some other meetings as well around that time in Africa. So this is very significant, especially post-Durban, where African governments were not sure about their position. But the significance of this has to do largely with African governments finally lifting themselves from under the propaganda machinery of Western academia. Western academia that built a historiography and a pedagogy upon an argument which was made in the emancipation discourses in the British Parliament and other European parliaments in the early 19th century. The slave traders, when they were told by the abolitionists that their business of slave trading and slavery were crimes, and the movement from slavery as unchristian, slavery as a sin, to the level that slavery was a crime. And that was the argument which pushed the legislation through the parliament. The slave traders responded by saying, no, well, if it's a crime, it's a global crime, because the African governments, by and large, are our partners, and therefore slavery and slave trading is a partnership between two commercial elites. That, of course, was an absolute dishonest and immoral argument, because on the one hand, they were speaking about the kidnapping, they were speaking about the terrorism that they had unleashed in Africa, the destruction of nations and of communities, the specific targeting of African elites to be destroyed if they stood in the way of slave trading and if they stood in the way of the business. Instructions were sent out from the capitals of Europe to destroy governments and leaders and monarchies that stood in the way. So it was a focused political act of terror that enabled the slave trade to continue. And then, of course, the exportation of weaponry, so that slave trading and gun trading, as it is today with narcotics and guns, a deeply bonded relationship between narcotics and guns. It was the same in West Africa, with Europeans dumping guns in West Africa. Indeed, guns were the main export to most West African nations in the 18th century. So we finally were able to persuade the African academic community and to some extent the political leaders know that you must not fall victim to this. These Europeans arrived highly militarized, highly armed, and unleashed a reign of terror. That reign of terror enabled the first phase of the trade to take place. The mayhem and the violence unleashed in West Africa by these corporations that were owned by the royal families in large measure, the royal families of Europe, with the full military backing of the state, so that phase one, which lasted for over 100 years until the middle of the 18th century, it was mayhem as these corporations extracted Africans for enslavement. Now, phase two, of course, meant that having broken the West African political resolve at the level of the state system, the struggle thereafter took place in communities. So many communities that had lost their political leadership resorted to a ground resistance, guerrilla warfare against the slave traders. And this was the period in which that ground war consumed thousands and thousands, hundreds of thousands of lives. Militarized gangs rode in through West Africa, avoiding the resistance struggle and kidnapping people. Now, the African voice is now emerging. The African voice is now emerging to speak about what actually happened in West Africa. And many of the royal families that have survived, many of them were driven to exile. Many of them developed a survivalist approach to the balance of power that has shifted in the favor of slave traders. These voices are now beginning to speak up. And we here at the University of the West Indies, we have invited 15 of these most articulate royal members, kings and queens, to come out here to the University of the West Indies. And they will be arriving in about 2 weeks' time. So we are going to have a symposium here at the University of the West Indies, which would be enabling these kings and queens of West Africa, those who have survived the Holocaust, to speak about their royal families as the leaders of these communities and how they were able to survive the slave trade. So these monarchs are going to be our guests here, and we are going to be in a position to compare and contrast the royal families of West Africa and their experience with the slave trade and the royal families of Europe, who own the corporations, who use state support to enforce compliance in West Africa, and who were the financial beneficiaries of slave trading because they own the companies, they own the stock. So we're going to have a symposium that looks at the royal families of Western Europe and the royal families of West Africa, the divergence of experience and how the slave trade enriched those European monarchs, but by and large destroyed the capacity of West Africans monarchs to rule and to administer their nations. All of these developments have been building out a broad base of political support for this movement, but critically bringing African states to the table. Another aspect of this that we have been deepening is to broad base the analysis of slavery and slave trading to include it not only as crime against humanity in specific relation to enslavement and chattelization, but we have also been building the bridge with genocide as a critical feature of slavery in the Caribbean. 6 years ago, I presented a lecture at Harvard Law on slavery as genocide. That lecture is on the YouTube and many people have been making reference to it. Last week here, again at the university, Professor Orlando Patterson of Harvard also presented a lecture here on slavery as genocide and presented some interesting demographic data to show the genocidal nature and the deliberate genocidal nature of enslavement in the Caribbean by European states and European slave investors. The interesting conclusion raised by Professor Patterson in the case of Jamaica is that just over 1 million Africans were brought into Jamaica in chains. At the end of 200 years emancipation, only 300,000 had survived. And the question was asked, how do you reduce 1.3 million people to 300,000 after 200 years? What Professor Patterson did was to compare the US situation, where a much smaller amount of Africans were took into the US. As you know, US, I think it was like maybe 10 to 15% of all the Africans brought across the Atlantic went to the US, and some 60% came to the Caribbean. But he compared the normal growth rate of the enslaved population in the US. And it grew considerably over the slavery period. And then he compared that with the Caribbean. And he said, if the Caribbean, or if Jamaica specifically, if the African population had grown at the rate at which it grew in the US, that today Jamaica would be, at the end of slavery, Jamaica would have had 6 million people. 6 million Africans. So basically what he argued is that the number of Jews who were massacred by the Nazi state, that 6 million figure which is used for the Jewish Holocaust, that was exactly the same figure that should be applied to Jamaica. That normal growth rates, Jamaica would have had at emancipation 6 million people and not 300,000. That margin he explained in terms of genocide. The data is even more striking for the case of Barbados, where 600,000 Africans were brought into Barbados. At emancipation, there were only 83,000. We're speaking across the Caribbean of less than 20% retention, survival. The population of Barbados today is just under 300,000, just under half the number of Africans who were brought into the island during slavery. The genocidal assessment is clear, is crystal clear. In the Caribbean, in terms of legal frameworks, we're speaking not only about commodification, chattelization. We're speaking about chattelization, the denial of human identity, the reduction of people to property status and law. But we're also speaking of genocide, deliberate systemic genocide, because the fundamental economic principle was that it was cheaper to consume the life of an African 7 to 10 years of hard, death-destructing life and work. It was cheaper and more profitable to consume the lives of these people in 7 to 10 years of extreme labor extraction and replace them. Buy them, use them up, replace them, go to the auction in the various ports and buy their replacement. That cycle of 7 to 10 years of extraction and then replacement was more profitable than developing a work regime and a nutrition regime that allowed these enslaved populations to grow. There was no growth concern, certainly for 80% of the slavery period. There was no growth concern. The discussion around growth only began when slave owners realized that the slave trade was going to be abolished, and therefore they needed to find a way to maintain slavery without a slave trade. So the genocide dimension is now also on the agenda for the reparatory justice movement in the Caribbean context. In terms of the calculations, the Caribbean position is that this region is in desperate need of an economic development program, that the systemic decline of Caribbean economies and competitiveness and profitability, the absence of capital in this region to modernize economies, to revitalize economic sectors, traditional sectors, agricultural, tourism, and so on, and to have investments in technology and research to create innovation in order to produce new economic sectors, that capital investments is not available in capital markets. And this region is in need of a development paradigm that invites investment on a win-win basis to promote modernization. And so the conversation is being built around a Marshall-style plan that the Caribbean never really had, because when these countries fought for their independence, the European governments, by and large, said, okay, the British government especially, okay, you want independence? Okay, you can have it. Now go. Sign here and go. No development support. No financial compensation. These countries went off into nation building in a horrendous economic situation, massive illiteracy, urban and rural decline and decay, inadequate infrastructure for school and public health. It was what you call a colonial mess. And these aspiring nation builders were told, okay, go and develop. Now, we believe, of course, that given the bad hand that was available to these nation builders, this first generation of nation builders, that they did well to convert that colonial mess into viable democratic nations. But all they have been doing was cleaning up the mess that they have inherited, hoping to lay the foundation for sustainable development. The British and European governments walked away from their mess and are of the opinion that they got away scot-free. We have correspondence to show this, and my recent book, How Britain Underdeveloped the Caribbean, is based on the correspondence and the records of the British government saying to the Caribbean, you're on your own, go off, and we owe you nothing. Despite all of the presentations from Caribbean prime ministers in the 50s, in the 60s, the political leaders from the trade union movement calling for an investment in the region to lay the foundation for independence. The British government made it perfectly clear that they owe the Caribbean nothing. They're going to give them minimum. They certainly will not get a development plan or development investments out of Britain, and sending these islands off on their merry way. The argument is now that the time has come for this conversation to happen in earnest, because it could not have happened before, because the colonial situation that persisted after independence was very strong. And these Caribbean governments had a great deal to sort out and building institutions to allow a nation to evolve. But now that process is relatively secure. This is the time now for that development conversation. And this is where CARICOM is pushing the analysis. There has to be a development plan, a Marshall-style plan for the Caribbean. And this is where the calculations are being made. This is where the calculations are being made for an investment strategy to build out the development infrastructural needs of this region. So the conversation around reparatory justice, around the legal frameworks, and also around financial calculations are taking place with intensity, but in respect of the latter, there is a growing agenda to invite the governments and private sectors of Europe to frame an investment strategy for this region that can promote economic development in this region. The conversation is not around creating calculations for individual cash endowments. The conversation in the Caribbean has not really gained traction around that principle. It has gained traction around infrastructure development, schools, hospitals, community institutions, reform, investment in agriculture, food security, investment in urban renewal and education, and so on, building schools and hospitals. That is where the conversation has gone, investments in the public good as a strategy for reparations. So I will leave it there, colleagues, and open to any questions that you might have. Thank you.
Thank you.
Thank you very much, Sir Hilary. Thank you indeed. There is a lot for thought in what you said. I found of particular interest your comment that the African voice is now emerging. There is so much misinformation and just sheer ignorance about what happened in Africa that led to our ancestors being transported to the Caribbean and the Americas. And so to have an African voice now involved, I think, is very welcome. Now, I listened last week, followed last week online, the fantastic lecture by H. Orlando Patterson, a Jamaican scholar and intellectual. He was 2 years ahead of me at the university, so I didn't really get to know Orlando, but his work certainly distinguishes him. And I'm very interested in your thesis, as well as his, that by the reduction in the Jamaican slave population from 1.3 million to, I think, about 320,000 at emancipation, there was effected a genocide in Jamaica. That's a bold statement, but I believe it can be substantiated. Now, H. Orlando, as we called him, I remember H. Orlando was called. He's a very distinguished sociologist, and he declared that he didn't have a lot of patience with this intent. The intent that is required to establish genocide is the most significant element of the Genocide 1948 Convention. Very, very difficult to establish it. But the way that you have put forward the case, I think, personally, I would love to be an advocate in a court arguing that that reduction in the slave population in Jamaica meets the standard, meets the required intent. And that intent is an intent to destroy in whole or in part a group. And as I said, it is notoriously difficult to establish. And I can say, as you know, I presided over the Milosevic trial. You recall that Mr. Milosevic died some 3 weeks before. And I can say now for the first time that although he was charged with crimes against humanity, war crimes, and genocide, I am not at all certain that on the basis of the evidence that was presented, the court would have been able to find genocide. In the result, we didn't have to, because regrettably he passed away. So that is a challenge, and the comparison with the Holocaust is very, very apt. But I just want to let you know that I found all of what you said exceedingly interesting and challenging. And I hope others listening would also have found it equally interesting and challenging. Not sure whether you wanted to say anything about the intent and how do you think the intent could be established. In law, intent is usually an inference that is drawn from all the circumstances. It's drawn from facts, and you're allowed to draw inferences.
Well, where I would begin would be by establishing that when it became clear in the capitals of Europe and in the Caribbean that the British Parliament was going to end the supply of Africans to the colonies, that in every major colony, Jamaica, Barbados especially, the slave owners went through a reversal in their economic policy. From the 1780s and 1790s in all of these colonies, the slave owners were getting together to talk about reversing their policy, that they will now have to grow a local supply. All of them developed incentives now to encourage the enslaved population to breed. They were all given now incentives. There are so many pamphlets written by them on the encouragement of slaves to breed. Instructions to managers of plantations, advising them how to turn the history around and get the slaves to reproduce. So there was an eruption of literature written by slave owners on the eve of the abolition of the slave trade on how to turn around 200 years of decline. And they acknowledged that their practice was genocidal. They acknowledged that their presence. And by genocide, let me define genocide as we historians have tended to do so. If you put a people, a specific group of people in a situation, and you practice economic policies and social policies around that people, and you enforce those policies in a way that that group of people could not possibly increase, but would significantly decrease generation by generation, so that you can see and witness the palpable decline generation by generation over time. But yet you enforce those policies even more aggressively, and the population rapidly collapses in the context of that environment and those policies. That is intent. That is intent, because the slave owners themselves, in their various parliaments and elsewhere in their correspondence, they made it clear it was cheaper for them to import, use up, and replace Africans than to support them with nutrition, support them with domestic infrastructure, and to allow them to grow naturally. Now we have the comparison because in the US, that is what happened. They gave them a regime of better nutrition. They tried to balance the male-female ratios on the estates. And while they were enslaved, nonetheless, an environment was created with policies, because in the US situation, they wanted the slaves to grow. They were more comfortable growing their slave population than having this annual infusion of Africans. The Caribbean policy rejected the strategy of natural growth. They rejected it. They only embraced natural growth, as I said, when the supply was going to be cut off. And then they produced a body of literature to explain why they were doing this. So the intent was always there because the intent was associated with an economic policy and a model, that it was cheaper and more effective to buy and consume than to support natural growth. So I don't believe that the intent argument is foreign to the Caribbean situation. It was deliberate, it was articulated, it was expressed, they knew it, they practiced it. And we also know when they tried to reverse it. And when you read letters, one of the great pieces of material published was a small book published in 1786 on the eve of the slave trade abolitionist discourses. And this book was written by the some of the six of the largest slave owners in Barbados. And the book is entitled, it's a little book, 15 pages, Instruction to Managers of Estates on the Growing of the Slave Population. And it sets out all of the incentives that should be given to slaves, especially to women. You give them some cash for the second and third child. You increase their nutrition. You give them milk, a pint of milk every morning. You give them more meat. When the woman became pregnant, as soon as the pregnancy is declared and is evident, you pull them out of the cane fields and give them lighter domestic work. Then you give them more financial incentives. And if they're able to give you 6 or 7 babies that are healthy, you can give them freedom for that. You can free the woman for that. And importantly, when the relationship was established between the male and the female, you would allow them to live in the same house. So you could put together a nuclear family in the slave cabin. The man and the woman can now live together as husband and wife with their babies. And as an incentive to that little household, you will not sell their children. You will not sell their babies off the plantation. They will stay on the plantation with their mothers and fathers. All of these prenatal and postnatal strategies were highly sophisticated and were designed to produce growth. And they did produce growth. But for 200 years, the management strategy and the policies produced genocide. So establishing intent. In the case of Jamaica, Barbados, I think it's very, very clear. The evidentiary basis of genocide, and if you want to use intent as a criterion, well, I think that is perfectly clear as well, what the intent was, and driven by profitability on both sides of the equation.
But as I said before, I'm willing to change my hat and to take on the case of an advocate I did work in the Attorney General's department, and I was an advocate in many, many cases, and enjoyed the role immensely, immensely. And of course, talking about the Jamaican genocide, it's ironical that the Jamaican slave owners, who were 35 times more wealthy than their American counterparts, did not see fit to treat their enslaved better, because they were financially more capable of doing that. And I think all of that, I think, would be part of the evidence that would be relevant to the establishment of intent. So I think the sociological truth, the historical truth that Orlando Patterson and yourself have shown in relation to Jamaica is, for me, is also a legal truth. It's a legal truth. And I think the case could be made. So for my own part, I want to thank you very, very much for the presentation. And
thank you.
I'm not sure whether there are other questions to be asked. I didn't intend to take up all the time, you know.
Well, I thank you for this invitation, and I wish the conference all the very best. Thank you, Judge. I appreciate it. Thank you.
Well, thank you very much, Professor. And we, of course, as usual, profited tremendously from your presentation.
Thank you.
I think next on the program is a presentation that I will make on some legal issues that are relevant to the quantification of reparations. And the first one that I'd like to deal with is the legal basis for reparations. What is the legal basis for reparations? The legal basis is the obligation imposed on the wrongdoing responsible state to restore the injured party to the situation that would have existed if the unlawful act had not taken place. And we find that principle reflected in Article 31 of the International Law Commission's articles on state responsibility. And it says that the responsible state is under an obligation to make full reparation for the damage caused by the internationally wrongful conduct. Now, the first form of reparations is restitution. But since it is not possible to restore the descendants of enslaved Africans to the situation that would have existed if TCS had not taken place, international law then requires that compensation be paid. But compensation alone cannot make good the damage caused by TCS. And in that case, the law requires that satisfaction be given. And as I said, that may take the form of an expression of regret, a formal apology, or any other appropriate modality. In my view, satisfaction will form an important component of reparations for TCS because monetary compensation will never be sufficient. There will be a need to ensure that programs are implemented to educate the descendants of the slave owners about the ills of TCS. Not long ago, a committee established by a government of the Conservative Party in the United Kingdom suggested that Black Britons benefited from TCS and that there should be a focus on what it called the positive aspects of that practice. This kind of revisionist approach has to be countered by specific policies. And there will be also a need for programs designed to reverse injuries resulting from TCS. And reparations should also include programs that memorialize the struggle of the enslaved for freedom. Now, since reparations are a legal response to wrongful conduct, it is appropriate to provide a few examples of such conduct. In the first symposium, we concluded that chattelization, which was characterized by the discriminatory treatment of Africans, was the essence of TCS, and it had 7 phases: capture and sale of Africans in Africa, the trek to the dungeons on the coast or to ships, internment in those dungeons or ships, the Middle Passage or the passage from Africa to Brazil, sale on the auction block in the Americas and the Caribbean, work on the plantations or elsewhere, and the concomitant trade in enslavement. Every single phase was unlawful conduct. And the first example of wrongful conduct I wanted to present to you has just been presented by Professor Beckles, and that is the genocide effected by TCS on the enslaved population in Jamaica. In sum, TCS was little more than a machinery that created killing fields, which regrettably remain in modern-day Jamaica. And this is an example of the wrongful conduct that must be addressed by reparations. Another example is the well-known case of Thomas Thistlewood. If you recall, his favorite punishment for a runaway from his plantation in Jamaica was to coerce another enslaved to defecate in the runaway's mouth, which was then gagged for about 3 hours. So with those 2 examples, and of course there are hundreds more, but that was the work of the first symposium, not this one. But with those examples, I want to turn now to reparations for the consequences of TCS in the period when it was carried out, and to highlight some of the legal issues that I raised. And the first one is causation. In order for reparations to be paid, it must be established that the alleged injury or harm is the consequence of the wrongful conduct of those states that carried out TCS. That is, in the language of the International Court of Justice, the ICJ, whether there was a sufficient direct and certain causal nexus between particular acts carried out in the practice of transatlantic chattel slavery and the injury suffered. That's causation. What about the standard of proof, or the degree of proof that is required to establish the causal nexus between the wrongful conduct of TCS and a particular injury or harm suffered? For example, loss of life. Ladies and gentlemen, TCS should be seen as a mass atrocity, as millions of Africans were subjected to this wrongful conduct. But there is no need to establish that a particular injury suffered by an enslaved person was caused by a particular act at a particular time and at a particular place. That requirement doesn't exist for mass casualties. In relation to such details, in the Democratic Republic of Congo versus Uganda, a war between the 2 states, the ICJ held, and I quote, "In cases of mass injuries like the present one, the court may form an appreciation of the extent of damage on which compensation should be based. Now, the particular standard of proof is fact dependent, and consequently, a flexible approach is required. In light of the particular circumstances in which a claim for reparations for TCS arises, I would submit that proof on the balance of probabilities is the most appropriate standard. That is, it must be established that it is more probable than not that the required causal nexus exists. I turn next to valuation. It is settled that in cases where it is certain that injury or harm resulted from a wrongful act, but there is uncertainty as to the extent of that injury or harm, there is a principle called the principle of equitable considerations, which may be used to determine the extent of the harm or injury on the basis of a reasonable estimation. You will hear from the Brattle Group. They do not make any explicit reference to this principle of equitable considerations, but you will hear them speak of assumptions. When hard evidence is not available, they work on the basis of assumptions, which are a kind of estimation. Now, what are the heads of damages in respect of which reparations will be due? I list them. They would include the following: loss of life, loss of income or earnings, personal injuries, non-material damage, a total disregard for the humanity and dignity of Africans, trampling over their identity, destruction of their culture, language, religion, and families, loss of personal autonomy, and self-hatred. Psychological damage may be presumed from the nature of the violations inflicted on the enslaved. Notwithstanding this presumption, the Symposium has found it very, very difficult to place a value on the psychological damage, both in respect of the enslaved as well as their descendants. And I'd like to take this opportunity, as I know we are streaming far and wide, to invite anyone listening to assist the Symposium by providing a basis for placing a value on the psychological harm caused by transatlantic chattel slavery. And I do hope someone will take up that invitation. There is also deprivation of liberty and deprivation of access to the courts. But of course, deprivation of liberty is the essence of chattelization, the loss of their freedom. And deprivation of access to a number of services, including those relating to health, housing, and education, sexual exploitation is another, and trading in enslavement. Now, the Brattle Group, you will see, they have their heads of damages. They do not employ at times the same nomenclature that I have used, but I am entirely satisfied that they correspond substantially with those that I have set out. So in light of the foregoing, it would be reasonable to conclude that on the basis of proof on a balance of probabilities, there is a sufficiently direct and certain causal nexus between each head of damage and the wrongful conduct as described above. That is, it is more probable than not that the required nexus exists. Consequently, reparations are required under international law. I now turn to reparations for the consequences of TCS in the period following its formal termination. Why do I call it formal termination? Because as you will see, although there were acts of the legislature in many countries abolishing chattel slavery, it continued. The essence of chattel slavery continued. Now, let us look at causation. The principal concern in this part is to establish there is a sufficiently direct and certain causal nexus between the wrongful conduct of TCS and the injury or harm suffered after its formal termination. The discriminatory treatment suffered by the enslaved did not stop after the formal termination of TCS. And it is for this reason that there is a direct relationship between the original act of enslavement and the discriminatory treatment of the former enslaved and their descendants in, for example, the Jim Crow period of 100 years after 1865 in the United States of America, and also the 1921 Tulsa massacre in the same country. In other words, just as discrimination through chattelization was at the root of the evil treatment of the enslaved in the USA, discrimination through chattelization is also at the root of the treatment of the former enslaved and their descendants after the formal termination of transatlantic chattel slavery. So let me turn next now to the question of a continuing breach. This concept addresses the extension in time of the breach of an international obligation. And Article 14.2 of the International Law Commission's articles on state responsibility provides that the breach of an international obligation by an act of a state of a continuing character extends over the entire period during which the act continues and remains not in conformity with the international obligation. In our context, there is a continuing breach because the discriminatory practices that characterize chattelization continued after the formal termination of TCS, and in a context where the obligation under international law not to carry out such practices remained. Professor Tendai Ashiyumi, a former UN Special Rapporteur on racism, cited this article in her report to the United Nations to show that discriminatory post-emancipation treatment of Black persons constitutes wrongful conduct for which reparations are required. Professor Ashiyumi's report is notable for the stress that it places on structural and systemic racism after the formal termination of transatlantic chattel slavery. That is the continuing breach. Now, we cannot overlook an important qualification that is in paragraph 6 of the International Law Commission's draft articles on state responsibility. The commentary on Article 14.2 cautions that, and here I quote, an act does not have a continuing character merely because its effects or consequences continue in time. It must be the wrongful act as such, which continues, end of quotation. But in relation to TCS, the symposium's position is that what has continued is the wrongful act of discriminatory treatment against Black people, and not merely the effects or consequences of such an act. The discriminatory treatment of Black people post-emancipation is not the effect or consequence of TCS. Rather, it is the continuation of the act itself, because discrimination is at the root of TCS. The heads of damages would look something like this: loss of human lives, for example, the killing and lynching of Black people in the Jim Crow period in the United States, personal injuries, non-material injury, such as I have set out in the first part, discrimination in the justice system, deprivation of the right to vote, and deprivation of access to a number of social services, including employment, health, housing, and education. Again, the Brackles Group's heads of damages are not exactly the same as those that I have set out, but they are substantially the same. In particular, wealth disparity is an appropriate tool to assess the deprivation of access suffered by Black persons after the formal termination of TCS to a variety of services, including health, housing, and education. Conclusion. In light of the foregoing, it may be concluded that on the basis of proof on a balance of probabilities, there is a sufficiently direct and certain causal nexus between the wrongful conduct of TCS on the one hand and the injury or harm identified in each head of damage suffered by the former enslaved and their descendants after the formal termination of TCS on the other. Therefore, it is more probable than not that the required causal nexus exists, and therefore reparations are required under international law. Those are the matters I wanted to address in identifying some of the legal issues that are relevant to the quantification of reparations by the experts. The next item in the program is what we are here to hear. It is the Brattle Report. Ladies and gentlemen, the Brattle Group is one of the world's leading economic consulting firms. We have with us today two leaders of the team, Dr. Alberto Vargas and Dr. Coleman Basilon. I apologize if I have mispronounced it. And they will present a summary of their work. Dr. Vargas is a principal at the Brattle Group, where he leads the broker, dealers, and financial services practice. He was born in Mexico City, where he received a BS in applied mathematics from ITAM, and where he lectured at the National Autonomous University of Mexico. He holds a PhD in economics from MIT and has over 10 years experience in economic consulting. As a consultant, he has led teams quantifying damages in forums, including civil courts and international arbitrations in Europe, the Americas, and Oceania. Most recently, he testified in front of a Royal Commission of Inquiry in Papua New Guinea on the overcharging by an international bank on debt issuances by that country's government. Dr. Coleman Pachelon is a principal at the Brattle Group. Outside of his leadership in Brattle's telecommunications, intellectual property, and sports practices, he has a long involvement in pro bono economic analysis. For more than a decade, he has served as the economist for the Martha Wright petitioners who advocate lower cost phone calls with the incarcerated in US jails and prisons. He has also served as an expert witness for the NAACP Legal Defense Fund in their litigation against the state of Texas's voter ID requirements. Dr. Barcelon also serves on the Maryland and national boards of the American Civil Liberties Union. Ladies and gentlemen, may I ask the two gentlemen to take the floor. Gentlemen, you have the floor.
Thank you very much. We have some slides we're going to use, and as we get them up, I will introduce ourselves. So we are presenting on a paper we have written that will be available through the conference website on the quantification of reparations for transatlantic chattel slavery. As noted, the Brattle Group is an economic consulting firm. Our day job is quantification of damages in litigations and arbitrations. And I believe we were asked to do this and because of that expertise, not because of our knowledge of the topic. I'm just waiting for Alberto to share the slides. There we go. So if we go down to the authors page, I just want to briefly acknowledge that although Alberto and I are presenting today, that this research was done collaboratively with many people at Brattle. There was dozens and dozens of folks who were contributed to this. The collaborators listed are folks who all gave more than a day of effort. But I especially want to acknowledge Mary and Rohan, who are really the backbone of the work and put in hundreds and hundreds of hours each, making sure that this work was done. I also want to acknowledge, want to thank Judge Robinson for the invitation to present this. We are really thankful and quite grateful for the opportunity. In developing our analysis, we rested heavily on feedback and comments from, in addition to Judge Robinson, Professor Shepard, and Natalie Reed. And also we wanted to specifically acknowledge Samantha Campbell and Michael Hiltons for their help in helping us navigate through the extensive research and data that's out there in compiling that and making it useful for our analyses. The assignment we were given was to follow up on the the first symposium that established a cause for harm. And in this second symposium, Judge Robinson asked us to estimate the quantum. Alberto, could you advance the slide? In doing this, we look to guidance from a number of sources, including the framework provided by Judge Robinson for reparations. The work of Professor Beckles and Professor Shepard was incredibly important foundation. And we also drew on broader academic literature on the various harms as well as reparation. We were asked to estimate, and I think this is the first time to estimate the harms for all of transatlantic chattel slavery. We were asked to identify those harms by country, both the harmed country in the Americas and the Caribbean, but also the enslaving countries. But as noted earlier, and just to be clear about it, we were not asked to apportion the reparations beyond the country level to individuals either downstream or upstream of those. So reparations, as noted, is really about the project of repair. And it encompasses much more than just monetary harm or compensation. But that's the portion of the project that we've been asked to focus on. So wanted to be clear that we are just looking at the compensation aspect of this. And as a reality check, also wanted to just acknowledge that even with the limited scope of the economic harm, the assignment of estimating the complete amount of quantum is really quite challenging, and we have not completed that. As Professor Robinson noted a minute ago, there are certain heads of damages, especially related to psychological damage, that we don't provide estimates for, and we'll leave to further work, and do appreciate the ideas that will come in on how to attract those, estimate those. But what we have done is taken some of the larger buckets of harm and estimated damages for them, but they're not complete. Wanted to just put our work in a little context. There are others who have provided estimates of reparations. They are broadly consistent with the work we've done, but somewhat different in scope of the numbers. So, for example, in the Empire Pays Back, there is an estimate provided of $4 trillion in unpaid wages. That focuses on British colonies, whereas our analysis is across all of the Americas and Caribbean. That analysis is broadly consistent with the work we're doing, in that it's based on about $1 million per enslaved person as a level of damages for unpaid wages. Our estimate's a little bit higher than that. Sorry, the pounds per unpaid wages. Our estimates are a little bit higher than that, but in the same area, but just applied to a much larger base. We do not, on the other hand, include an estimate directly of the unjust enrichment, although aspects of that do feed into some of our analyses. And many others have been provided. For example, the more recent Darity and Mullen analysis of reparations is focused on, again, just on the United States. It's based on a wealth disparity measure. That is one component of what we provide. Our number is a little different than theirs, but very close to it. But our estimate is more comprehensive in that, again, it goes well beyond the United States. And then finally, I'd like to just give a brief overview of the presentation, the approach that we're going to provide. First, we divide our analysis into two large buckets of analysis, or periods. We estimate the harms during the period of enslavement, and then separately post-enslavement. Within each of these areas, again, I want to reemphasize that there are some things we measure and there are some things we were unable to measure. And we try to be clear about that. And for anybody who spends any time with this topic will realize that when we're talking about harms that span centuries and have to be accounted for over hundreds of years, the use of the interest rate is just a fundamental key part of this analysis. And so wanted to be very upfront about that. An interest rate, which is used to translate a value from one period of time to another, has three components to it. It's accounting for three different things. One is the purchasing power of money, so that you're able to purchase the same set of goods with the amount of dollars. That's the inflation component. And over these long time periods, we use about a 1.5% estimation for inflation. The second component of an interest rate has to do with the time value of money, or just simply how much I have to pay you for the delay in receiving a payment. And that's the real interest rate. That we estimate, or we use a 1% real interest rate over these long time periods. It's worth noting that's a conservative number, and there's a much longer discussion about this in a paper. But together, those equal about a 2.5% interest rate, which we use. We also don't make any adjustment for the riskiness of the investments for default risk, under the assumption that the countries that owe the money today are able to pay it. That would be another area of risk, and we do provide some sensitivities for these in our presentation, and more of them in our paper and analysis. So with that, I'm going to turn it over to Alberto to start us off on the period of enslavement, and I'll pick back up later in the presentation. Thank you.
Thank you. Thank you very much, Coleman. And thank you, Judge Robinson, for the invitation. And I must echo the thanks to everyone who helped us either by providing comments or helping us with the data availability for this particular project. So we will begin by discussing the calculation of damages during the period of enslavement. And as Coleman already noted, we will divide these into two broad categories. The categories where we can provide an actual estimate of the quantum of damage, and others, then the second category are heads of damages where we are unable to provide an estimate. For the categories where we are able to provide the estimate, you will note that the order in which we present them may be somewhat counterintuitive. The more intuitive approach would be to begin with loss of liberty, which is the origin of all the rest of the damages. However, the way in which we will present them is what we've been referring to as a building blocks approach. Unpaid wages and loss of life will provide a very concrete methodology that allows us to anchor the values of the rest of the damages. Therefore, we discuss first loss of life and unpaid wages. We will treat them as a single combined head of damages, and then we will anchor the value of the rest of the heads of damages to that combined loss of life and unpaid wages head. That does not mean that we do not recognize the importance of other damages that happened during the period of enslavement. Everything from psychological mistreatment, family separation, political disenfranchisement, and social isolation. And I am sure we are missing many, many more from this list, where part of the horrible damages and harms that were experienced by the enslaved, we want to recognize that we are aware of them. We also want to recognize that the tools that we have at hand at this moment do not allow us to calculate damages associated with these heads of damages. So with that, let us set the stage for the calculations that we will be presenting. Much of this data is, or or at least part of it, is probably well known to a good portion of the audience present here today. We begin by looking at the number of embarked enslaved people that left Africa and sometimes European shores, but mostly Africa, headed to the Americas and the Caribbean. As we know, not all of those survived the Middle Passage, so we disentangle those who were actually disembarked, that were roughly 8 million people, and those that died in the Middle Passage, roughly 1.2 million people. Here, it is important to note that we will be calculating damages associated for both. And I will go into further detail on how we do not make an important methodological distinction between those who actually disembarked and those who died in the Middle Passage for the purpose of calculating the damages. In regards to those born into slavery, here I must make an important caveat in that there is a big estimation component to this number. Whereas for the embarked and the disembarked, we actually have access to the records of the people who were enslaved and transported. We do not have sufficiently rich data to affirm that we have a precise number for those born into slavery. For the case of the United States, we do have records that allow us to present the roughly 7 million number that we see for the United States as data-based. For the rest of the countries, we adopt a methodology that was first presented in the documentary that Coleman already made reference to, The Empire Pays Back, where they assume one birth into slavery for every three enslaved person that was transported to the Americas. Adding all of these numbers together gives us the staggering amount of almost 20 million people who were enslaved and on whom we will be calculating damages. Now, the table as we presented in this slide is a little bit overwhelming. There's far too much to take in. Perhaps an easier way to see who were the nations involved in enslaving these 19 million people, we can see this graphical representation. Portugal and the United Kingdom, or its predecessor states, share the greatest portion of the number of enslaved people. Between the two of them, they are roughly half of the 20 million that we saw in the previous page. Note that this chart talks only about the embarkments, so that is why it won't add up to the 20 million that we saw. We are not taking into account those born into slavery. Behind Portugal and Britain, Spain and France follow closely, and Brazil shows up as it continued with it continued having enslaved people even after independence. Now that we have a sense of the number of people on whom we will be measuring the damages, let us go into the actual methodology. As I mentioned earlier, we will be combining uncompensated labor and loss of life into an estimate that we refer to as foregone earnings. Let me unpack that a little bit. Loss of life is a head of damages that has been measured in many ways in the economic and the actuarial literature. One of the most frequent ways in which this has been measured in recent years is the loss of productive life approach. The idea behind the loss of productive life approach is that the harm, or at least the economic harm experienced through untimely death, is equivalent to the foregone earnings that person has foregone because of their premature death. Now, this translates into a simple calculation of what would have been a person's expected life expectancy at the time of death, were it not because of the harm or because of the accident for which we're measuring the damages. Meanwhile, uncompensated labor is simply the number of years that the enslaved worked and was not paid for. So in both situations, we have that a number of years is multiplied by the wage that should have been paid to that person. If we add up the number of years in both situations, we have, first of all, for uncompensated labor, that the number of years is the number of years that the enslaved person actually worked. For loss of life, it's the number of years, the number of additional years that the enslaved person would have lived had they not been enslaved. If we add up those two numbers together, it is actually the life expectancy at the age that the person was enslaved for a free person. So it is the amount of time that, in our base example, say at age 20, a non-enslaved person would have been expected to live. And then we multiply that number of years times the wage that a free person would have lived. Again, all of this is presenting a number that is what would have been this person's lifetime earnings were it not because of their enslavement. They would have lived, or they would have been expected to live as much as a free person, and they would have been expected to earn per year or per hour the amount that a free person would have been expected to earn. This simplifies our calculation to multiplying two numbers, the life expectancy of a free person times the wage times every single one of the 19 or 20 million people that we are looking for. Now, here because of time limitations, I cannot go into all the assumptions that we had to use in calculating this, but I will mention a few since they are important, and we will talk about how important those assumptions are or are not to the final number later in the presentation. The richer data that we found available for life expectancy going back the centuries that we care about was for the United States, and the same for the wage of a free person. So what we do, and I will discuss this in a little bit more detail in a second, is take the case of the United States as a base case. So we have data from the Massachusetts Bureau of Statistics that allows us to have wage data from a single place, from single geography, ranging from the 1700s to the 1800s. We anchor our calculations to this wage level, and we also anchor our life expectancy to the life expectancy in the United States for the relevant periods. Other assumptions that we make are that the enslaved were captured at an age of 20. So whenever we calculate the damages associated with someone who was captured into slavery, we take their life expectancy at 20. Again, that would be the life expectancy of a non-enslaved person at 20. For those born into slavery, we follow academic literature that conducted similar calculations, and we assume that slave work began at the age of 5 for those born into slavery. So what is the end result of this? By applying this methodology to all the countries in the Caribbean and the Americas, we end up coming up with a calculation of $54 trillion in total in reparations for loss of life and loss of wages. So this is, even though Coleman presented some of the results from prior literature, this is the first time we are presenting a calculation of our own. And I recognize that these are staggeringly large numbers. At the end of our presentation, we will aim to put these staggeringly large numbers into context. So I think that all of us have a very strong gut reaction whenever we see a number that begins with trillions instead of millions or even billions that we are used to seeing. One thing I would highlight about this is that the damages are split almost evenly across three geographies, three broad regions: the Caribbean, South America, and the United States, with Central America and other territories having much smaller damages. Another point that Coleman highlighted at the beginning of his presentation was the importance of the interest rate. So what we want to highlight at this point is the importance of two of the assumptions that we are making. As I said, a lot of our analysis is anchored on data available for the United States. So we want to show two things in this with this chart. One, the huge importance of the interest rate when conducting these calculations, and second, the relative importance of other assumptions. If we go across the columns, what we show in each of the different columns is what happens if our assumption that wages were the same everywhere in the Americas as they were in the US. What happens if that assumption is not accurate? And we look at a pretty broad set of assumptions, ranging for what if we assume that everywhere else wages were 75% of what they were in the United States? Or in the other extreme, what if they were actually 125%? And here it's important to note that either of those assumptions could be a reasonable outcome. Most of the work that was performed by the enslaved happened in pre-industrial societies. So the wage disparity between the United States and other territories was not necessarily in one direction or the other, as it was likely driven by what economists refer to as the marginal productivity of labor. That is, given the characteristics of, say, the land or other geographic characteristics of the place where the enslaved worked, an enslaved person could actually be much more productive in places where the land allowed to produce very valuable crops. So the key observation of that comes out from doing this sensitivity analysis is that there is certainly variation when we move this particular assumption, but that variation is relatively or absolutely small once we see what the possible variation is when we move the interest rate. So each row in this table represents the values for under different interest rate assumptions. The very first row assumes that no interest rate is paid. So if we assume that interest should not be paid for these reparations, which we would never take as a reasonable assumption, we would end up with $190 billion in reparations. That is the middle number in the first row. if we assume that only 1% interest should be paid, that number becomes $1.5 trillion. So by going from 0% to 1%, we've almost multiplied 10 times the magnitude of the reparations. As Coleman mentioned at the beginning, our base estimate is based on a 2.5% interest, which is roughly inflation plus 1% real interest. That yields a $54 trillion estimate in our base scenario. If we reduced this interest rate by 0.2%, we lose almost a third of the value of the calculation. If we reduce it by 0.4%, so we make it 2.1%, we are losing almost half of the calculation. So it is a point that I think we cannot stress enough, the importance of the interest rate and how all of these interest rates that we are showing, even the 5%, which produces numbers that are so staggeringly high that we wouldn't even know how to put them in proportion within the magnitude of the world's economy. Yet 5% is an interest rate that has been observed over the past 500 years. And a case could be made that some investments have reasonably grown without rate risk at those levels. So we will come back to the discussion of interest rates once we've investigated the rest of the heads of damages. This is the first introduction that we make to them. Then we go to the second or third head of damage, loss of liberty. Here, our analysis is based on the academic literature on manumissions. So the academic literature has looked at, we found some empirical work where through the analysis of manumissions, the authors managed to separate the value of the labor as understood by the slave owners and the value at which the manumissions actually occurred. And they conclude that there is a rough 20% discrepancy between the two. The interpretation is that that 20% is the actual value of giving the freedom to the enslaved. The value at which the enslaved values the freedom beyond the economic benefit that he or she will receive from being paid by its labor. So the calculation that we do to come for a quantification of damages associated with loss of liberty is apply that 20% to our foregone earnings calculation, and we arrive at a base value of 10.9, almost $11 trillion. To check how reasonable this approach to calculating loss of liberty was, we looked at two other approaches. The first one was looking at, in the case of the United States, what is the compensation for false imprisonment paid across multiple states? We end up seeing that a reasonable calculation of the average is roughly $38,000 per person. And then we multiply that times the number of enslaved life years. And here we come across another staggering number that we have to keep in mind when we consider the total numbers that we present for reparations. 801 million life years of enslavement. This is at least to me, an even more staggering number than thinking of 20 million enslaved people. 801 million years of enslaved life is an overwhelming number for me. But we must go back to the calculations. By doing this approach, we arrive at an estimate of $30.1 trillion in loss of liberty. The third approach that we looked at was calculate the compensation that was paid in the United States to those interred in, to the Japanese and Japanese Americans that were interred during the Second World War. This gives us a smaller number of $10.7 trillion when we apportion it to what the equivalent would have been for the enslaved. So this gives us two additional measures, one with a larger, one with a smaller final outcome than our base calculation, which gives us comfort in that our base calculation is of the right order of magnitude. The next head of damage that we look at is personal injury. Personal injury will also be anchored on our foregone earnings calculation, in particular as it refers to loss of life. Here we have the benefit of a very detailed methodology presented by the 9/11 Compensation Fund, where the fund compensated simultaneously for loss of life and for personal injury. And we take a relatively simplistic approach where we find the ratio of the average award for personal injury to the average award for loss of life, and find that on average, personal injury was compensated by an amount of 11% of the average loss of life compensation. We apply that same ratio and we assume that everyone who was enslaved suffered personal injury, an assumption that I hope will not be controversial. And this leads us to a calculation of $6 trillion in damages for personal injury. Now, for the next head of damages, I will hand over the presentation to Coleman once more, and he will talk about the fourth head of damages that we can calculate, which is compensation for gender-based violence.
Thank you, Alberto. So picking up on this last area that we estimate harm during the period of enslavement is for gender-based violence. As noted earlier, this is rape, forced pregnancy, and other types of sexual abuse. Here we are trying to estimate compensation for this harm that is above and beyond compensation that's already been paid. So we conceptually, at least, this is not about the loss of liberty, forced confinement, loss of wages. It is intended more to focus on the psychological harm from this head of damage. The first assumption we make is, although we recognize that there was gender-based violence and sexual assaults against men and children, we're going to focus on what we understand to be the majority of the harm, which was against enslaved women. And the first step is to estimate the number of enslaved women. And looking at research both on during the period of transport and subsequently, we come up with an estimate that about 35% of all enslaved people who came to the U.S. plus came to the Americas plus were born here were women, and that other research has shown that more than half, about 58% of adult women who were enslaved experienced sexual assault. So combining those two numbers of the amount of women and the adult women, the share of them that this research suggests suffered this harm, that gives us the number of individuals and the number of years of their lives that we want to use in our estimation. Here we turn toward, if you can go back just a sec, here we turn toward other judicial determinations of harm for the amount that we are going to apply here. And we look across a broad variety. They're largely applicable, but not exactly the same as what we're trying to estimate. And there's also an issue, a methodological issue about these amounts of compensation are for distinct periods of time, whereas we are trying to estimate lifetime levels of harm. So we take as a base, using our judgment as a base from these judicial determinations, an average of about $50,000 US per year of adult harm for this, and that together then ends up with a estimation of harm, which on the next page brings these all together. And when you multiply them out for both folks that came to America and the Americas and were born here, we end up with an almost $7 trillion estimate of harm, this last head of damages. So now taking things, it's really 5 heads of damages, recognizing that foregone earnings encompasses 2 distinct things, the lost wages plus the loss of life. If we add them all up, the wrongful conduct during the period of enslavement is approaching $80 trillion, almost $79 trillion. We're now going to turn toward the period of post-enslavement, and then all of this will be put in, these staggering numbers will be put in context soon. I think it's worth noting we've also unpacked these by this estimate by the enslaving countries and the harmed regions. We have the details by country, the full matrix, and we'll present that for the total set of harms of both periods at the end of the presentation. So moving to the period of post enslavement, the first thing we want to recognize is that there are many continuing harms that happen after emancipation. Alberto, if we could go to the next slide. We use as our summary measure, as I think others who have done research in this area have done, is a summary measure for the harm from this period, wealth disparities between, well, I'll get into the details of how we calculate it in a second. We're also going to provide a recognition that there are, beyond what's captured by the wealth disparities, there's many other continuing harms, and we are going to give some indication of those. But again, it's really important for us to acknowledge that we're not capturing the full scope of harms from this measure or this analysis. So the wealth disparity, which is at the heart of what we're estimating here, is intended to capture the economic harm post the period of enslavement. In essence, what it's trying to get at is that if after a person is freed from slavery, if their ability to get a job, the type of job that they get, the amount they're paid for the job is all diminished because of their status, they'll earn less income than they would have as a continuing legacy of slavery. And that lower income is going to have 2 effects on them. One is their consumption, the quality of their life, what they're able to consume, the utility they get will be lower during their lifetimes, but it will also mean that they will have less wealth to leave to the next generation. And when that generation then sets out and experiences those same harms, they start at a disadvantage because they have less wealth. And this process accumulates over time and ends up with our measure of the wealth disparity experienced today. We estimate this in sort of two buckets. For the United States, we're able to look at the difference between white and black people in the US and the wealth, the average wealth held there. And our estimate of disparity is the difference in value, and the difference in these average amounts of wealth times the number of black people in the US. In essence, it's the amount of money that would eliminate the wealth gap within the United States. For the rest of the Americas and Caribbean, what we do is estimate the difference in average individual wealth between the countries that the slave trading countries and the countries in the Americas. This measure is a little different and is a little less precise, I think, at what we're trying to get at. So I wanted to just take a moment to give the reasons why we still think it's a useful measure. I first want to recognize that what we're measuring is we're trying to get a measure of the economic harm caused by slavery, and that some of the wealth differentials that we're measuring could be caused by non-slave related colonial practices, and that there could be other reasons for this wealth differential. I suspect that could go in a couple of directions, but to the extent that there is wealth differentials associated with something other than transatlantic chattel slavery, then our estimate on that dimension will be overestimating the wealth differential. On the other hand, because we're using average wealth in a country, we are not taking into account wealth differentials within the countries in the Americas, and to the extent that for some countries, as is very stark in the United States, but for other countries that there is color-based wealth differentials, we are not capturing those, and in that sense, we are probably underestimating the quantum of wealth. The conceptual argument we're trying to, or exercise we're trying to do here is answer the question of what would the wealth differential be had there never been transatlantic chattel slavery? And our assumption is that there would be no wealth differential. We don't know that that is necessarily true, but given that this measure of economic harm for the period that it's applied is conservative in nature, as noted, it does not capture some of the consumption effects along the way. Plus, it doesn't capture some of the other effects that I'm going to talk about in a second. Given the conservativeness as a nature, even if this particular measure slightly overmeasures the wealth differential, we still think it's a good measure of reparations. And there's more of a discussion of this in our paper. So moving on to the estimates. In the United States, as I noted, we could look at the differential in individual wealth by race and see that the wealth gap, the difference in wealth between Black and white citizens of the United States, is over $250,000. And applying this number to the more than 41 million Black people in the United States gives us a wealth gap of about $11.5 trillion. This is on par with other measures of the wealth gap, slightly lower than the Darity and Mullen. For the rest of the Americas, as I noted, we look at the gap in wealth between the enslaving country and the destination country. And again, it comes up to just over $11 trillion in total. Taking these two together is a almost $23 trillion estimate. And this is the number that we put forward for the harms from the post-enslavement period. We have, again, calculated it by country so that we have the full matrix. This is just a summary of it. And when this is combined with the period of enslavement harms, for our total estimate, we have a chart at the end that'll talk about that. I did want to just acknowledge that one of the issues around the wealth gap analysis is that even if the wealth was equalized today, that doesn't mean it would stay equalized going forward, because all the same mechanisms of harm that have caused a wealth gap would continue without a fuller set of reparations or restorative justice here. So those additional harms, we go through a number in the paper. I have a few of them here, but it's just to say that that the difference, the ongoing harms and legacy of slavery in the Americas is much more than just the economic harms, and that without addressing the full set of disparities, solving the economic problems would not be sufficient. And with that, I'll turn it back to Alberto to try to put some of these staggering numbers into.
Thank you, Coleman. So let's begin by summarizing. We've been throwing a lot of numbers around. It's probably a good idea to begin by looking at how everything adds up. Coleman just presented the summary numbers for the post-enslavement period that come at around $23 trillion. We had talked about roughly $78 trillion split between gender-based violence, personal injury, loss of liberty, and foregone earnings that make up the harm during the period of slavery. If we add up everything together, we end up with the staggering number of just over $100 trillion. We can apportion those $101 trillion across the destination countries for the enslaved and across the enslaving countries. Not surprisingly, if we look across the enslaving countries, we find that Great Britain, Portugal, and Spain carry the largest total harms, with close to $20 trillion each. The United States carries an even larger number, even though, as it has been mentioned earlier today, the United States was not as large a destination country for shipments of enslaved people. However, the number of people born into slavery in the United States was staggeringly larger than in other regions, and therefore the number of enslaved people in the United States ends up being substantial. So what does this all mean? $100 trillion is an astonishingly large number. And of course, it can be, depending on the interest rate assumption, like most of our analysis, it will vary with this assumption. If we were to take 1.7%, which is a reasonable approximation for inflation over the past 4 centuries, we still have close to $40 trillion in damages. If we take a really minimum amount of interest, 1%, we still have $30 trillion, especially driven by the post-enslavement harm, which, as you can see in the table, does not depend on the interest rate. I want to make a quick comment on that. The post-enslavement harm is, because of our methodological approach, measured in current dollars, and therefore doesn't need to be brought to the present using an interest rate. That is why you will see that across our different interest rate assumptions, it doesn't vary. But what does this all mean? Whether we're talking about $30 trillion or $100 trillion, we need to put those numbers in context. Some previous analysis has gone down the route of comparing similar exercises to the magnitude of the GDP of a particular country. So we could be looking at damages for US slavery and compare it to GDP, and we come to the conclusion that that the numbers are comparable, or for some calculations, sometimes even the calculation of reparations is larger than the GDP of that country. Well, that is a very good first approach when trying to grasp a sense of the magnitude of these numbers. There are a couple of things that need to be taken into account. These numbers measure damages that occurred to millions of people over hundreds of years. GDP is a measure of output for 1 year. Using the GDP of a country to grasp the scale of these numbers is hardly the appropriate measure. We would be comparing hundreds of years of damage to 1 year of output, to put it bluntly. So what we do is, instead of looking at a single year of output for the enslaving countries, we look at the cumulative GDP in this particular case from 1950 to 2020. And here we see that the total reparations are relatively small to that total output. In particular, in the United States and in the United Kingdom, we can see that this, the green, which represents our calculation of reparations, are relatively small. And even here, we are calculating 70 years of output to hundreds of years of damage over millions of people. Another way of comparing these numbers is against the share of wealth, how they would stagger next to the total wealth of these countries. And here we see a lot of variation. For countries like Argentina, whose actual number in terms of dollars is not that large, we see that there would be a very large, they would represent a significant proportion of that country's wealth. While for the United States, that has the largest number in terms of the reparations calculations in dollars, has a relatively small portion as a portion of their wealth. So it is with these comparisons that we want to finish this presentation. We have shown you calculations that bring together an approach to assess the harm across the entirety of the Americas, using methodologies that had been used for separate parts of the Americas or for certain portions, for certain heads of damages. But here we have combined everything together. The result is a very large number that remains very, very large, even if we run robustness checks on our assumptions. But a large number that, when we see it in the context of the depth of the harm, the breadth in terms of the number of people who were harmed, and the duration of the harm in the hundreds of years over which it was inflicted, begins to make sense. A number that large begins to make sense once you take into account the breadth, the depth, and the duration of the harm that was inflicted. Unless Coleman has something else to add at this point, we will be happy to take questions.
Good. That's it for us.
Are there any questions for the two presenters? If not, I would like to thank you both very much. It's a very technical matter, but I believe you made the difficult issues very understandable, and I congratulate you for that. So we'll now take the break and resume at I think 1:30 p.m. for the first discussion panel. That will be 7:30 p.m. in the Netherlands where I am. So thank you both very much, and I look forward to keeping in touch with you, because I'm sure there will be matters that we want to address as we move forward. So once again, very grateful to you.
Thank you, and there's much more work to be done here.
Yes.
Thank you.
Thanks. Thanks. Turn it off.
It's gone, yeah, this weekend.
So-
Is the tea cold now?
Greetings, everyone. It gives me great pleasure to convene the first discussant panel for this, the second symposium on reparations under international law for enslavement of African persons in the Americas and the Caribbean, following the first symposium that was held in 2021. Welcome. We've already had a very rich series of discussions today. We heard powerful opening remarks from Greg Schaefer, President of the American Society of International Law. Judge Robinson, I'm getting a message from you that you're having trouble hearing me. Let me do a tech check. Can you hear me? Okay, I'm getting word that I can be heard, so I will continue. Welcome, everyone. This is the first discussant panel for this, the second symposium on reparations under international law for enslavement of African persons in the Americas and the Caribbean. We've had a very rich series of discussions today. We heard powerful opening remarks from Greg Schaefer, President of the American Society of International Law, and from Vereen Shepherd, Director of the Center for Reparation Research at the University of the West Indies. We then heard insightful and illuminating presentations from Judge Patrick Robinson of the International Court of Justice and from Sir Hilary Beckles, Vice Chancellor of the West Indies. Judge Robinson and Sir Hilary Beckles provided an overview of legal and economic aspects of the case for reparations. Finally, we were able to hear the report from Coleman Bazelon and Alberto Vargas of the Brattle Group Consultancy, presenting findings from a larger team of researchers who devoted their considerable expertise to providing and substantiating estimates for damages both during and after the period of formal transatlantic chattel slavery. That report, with the rest of today's earlier discussions, sets the stage for the current panel, in which we'll have the opportunity to hear from three distinguished speakers, Professors Mamadou Abiye, Adrian Wing, and Don Marshall. We will hear from the speakers in that order. I'll briefly introduce them now, and then I'll turn the floor to Dr. Abiye. Thank you again for joining this discussion. So first we'll hear from Dr. Mamadou Abiye, who's Associate Professor of International Law at the Grotius Center for International Legal Studies at Leiden University. He holds a PhD from the Graduate Institute of International and Development Studies and is also a graduate of Harvard Law School, the Geneva Academy of International Humanitarian Law and Human Rights, and the Hague Academy of International Law. His thesis on agreements concluded between colonial powers and local political entities as a means of acquiring territorial sovereignty was awarded the Paul Guggenheim Prize in International Law in 2016. He's also served as lecturer at the Graduate Institute of International Development Studies and a special assistant to the President of the International Court of Justice. Next, we'll hear from Professor Adrian Wing, who is the Associate Dean for International and Comparative Law Programs and the Bessie Dutton Murray Professor at the University of Iowa College of Law. She serves in a number of other leadership roles as well at the University of Iowa, including as the director of the Center for Human Rights. She's an author of more than 140 publications and is the editor of the groundbreaking volumes Critical Race Feminism, A Reader, and Global Critical Race Feminism, an International Reader. Her US-oriented scholarship has focused on race and gender discrimination, and her international scholarship has emphasized Africa and the Middle East, international law and feminism, international law and race, and the Arab world and women's rights, among other topics. Last but certainly not least, we'll hear from Professor Don Marshall, who is University Director of the renowned Sir Arthur Lewis Institute of Social and Economic Studies at the University of the West Indies. He sits on the boards of a number of key scholarly journals and has authored the volume Caribbean Political Economy at the Crossroads, NAFTA and Regional Developmentalism, published by Palgrave Macmillan, and he's the editor and co-author of a number of other volumes and articles. His research has centered on addressing the Caribbean international political economy complex over time, with the express aim of highlighting where development transformation is possible via the structural opportunities on offer at specific conjunctures. And he's also focused on industrial policy issues and democracy and governance in the Eastern and wider Caribbean. So we truly have an eminent panel of commentators, and it's my great privilege to be able to convene this panel and begin this discussion. Dr. Ebiye, I now turn the floor to you.
Thank you very much, Professor Thomas, for this kind introduction and for giving me the floor. I hope you can hear me well, and there is no problem. So, yes, okay. I would like to thank the organizer for this opportunity they're giving me to comment on the quarterly report and to engage for a second time with this very interesting question of reparation of the breaches of international law that occurred during slave trade. It's also the opportunity to commend Judge Robinson for carrying on this project to the end and for bringing all of us together to the discussion table. My third note of thanks goes to the Bratton Group, which has produced a fantastic report. I have to say the report is very clear, easy to read, I would say even for international lawyers. So it deals with maths, it deals with numbers, but really it's very accessible. And I was extremely impressed by the way that they have been able to make clear the different parameters that they are taking into account when they are assessing the amount to be paid for the breaches of an international committee during slavery. I was also admirative of the fact that the assumptions were clearly stated, and this really facilitates the legal reasoning. But here I am a discussant, and I need to find a number of issues that I could highlight. And my perspective has been to identify some key issues which I believe someone who would not share the agenda to pay reparation may raise when he or she receives the report. So my goal is really to make sure that we are all, we look at the report from also its, what I could consider areas where it could improve, so that we look at areas where the report could be improved. And although I don't have an answer to all the comments or all the issues that I could sense, I think that it is it will be useful to raise them at this stage. And I think I will just make 4 comments, 3 that are methodological, and 1 which is substantive and concerns the place of Africa in the report. So concerning the first 3 methodological comments, I saw that different juncture in the report decides to go systematically for the lowest number of their estimates. So for instance, if you read at page 97, the number of people born into slavery, after taking into account the different parameters, the report decides to take what it considers to be the lowest bound of the number of people that were born into slavery. And when I read that, what I had in mind was how is it going? Champagne? Yeah.
Mamadou, just checking with you. Is everything all right? We were getting a little bit muffled sound, but otherwise you look good.
Okay, is it better?
This is better. Yes, you are clearer.
Okay, so let me just change. Okay, turn the camera on. Okay, good. So let's let them continue. So I was saying that I would make 3 methodological comments before making a substantive comment which relates to the place of Africa in the report. And with respect to the first methodological comment, I noted that at different junctures in the report focuses on the lowest number of their estimate. So for instance, when they're assessing the number of people born into slavery, the report decided to look at the lowest number that they could find. I understand that this can be explained by caution, by the fact that we want to remain on the safe side. But the question is whether this is a legal issue, which should therefore be assessed as a matter of law, or whether it is just a matter of assessing the damages or calculation, which could be left to economists. And it seems to me that at least if it was at an international court or tribunal, it will be rather the court who will decide what is the degree of certainty that it has with respect to the different numbers. And probably it will not systematically go for the lower number of the estimate. But Judge Robinson is with us, and I would like to hear his views on this point. So perhaps it might be useful for the report to indicate the lowest bound, what could be the average, and I will say the maximum number, and then leave it to lawyers to find the criteria that they believe, as far as accuracy is concerned, to determine what is, as a matter of law, the correct, at least the number which can be judicially approved. My second concern also relates to a statement that I found in the report, and it really relates again in this articulation of task between lawyers and economists in assessing damages. And it reads at page 36 that sexual violence against slave women was legal at that time. And in footnote, you have a reference to a judgment of the United States Supreme Court. Having worked a lot with colonial history, I came to be a little bit skeptical about this kind of statement. And I'm not making a firm view as to whether it is correct or not. It's just that I believe that the issue should be investigated a little bit more in order to, before before taking it for granted. But if I was to speak, not just as a lawyer, but just as a matter of legal reasoning, I would say one thing. The reason why this kind of statement tend not to be true is the fact that it's not the law, the law prohibits rape. Now, you consider that a slave is not a human being, and therefore you use it as a property, including committing sexual violence against her. If later it is proved that you were wrong in your characterization of a human being as a property, I don't think that this makes your act lawful. So it's from this background that I come from, and that's the reason why I look at it with Yes, with some reservation. So what I was wondering whether in areas such as this one, if it was not better to rely more on legal input and not take things easily for granted. And thirdly, I had a sense when reading the report that the report was relying extensively on US practice. And to give you an example, I remember that when trying to ascertain the percentage of physical injury, the report used as a base rate the percentage of physical injury that occurred during the 9/11 terrorist attacks. So it's difficult. It's difficult, and I don't have an alternative because it's very difficult. There is no way to know exactly whether in the US, in different places where slavery was taking place, what was the percentage of physical injury compared to death. But it seems to me that if to the extent possible, and I understand that it can be just practically impossible to do it, but it will be good to try to diversify the sources of base rate. And there are parts in the report where this is done, but there are more areas where US practice is quickly taken into account. Now, there is one area, one substantive comment that I would like to make, and it relates to the fact that the quantum of the damage that is calculated does not take into account the damage that could be owed to African countries themselves. And I agree with Sir Beckles that if we want this reparation project to be successful, it will require the combined effort of African countries and the Caribbean and all the descendants to push in the same direction. So I was wondering whether it will not be good to take into account also the compensation and try to estimate the compensation that would need to be paid to African countries and people in Africa for slavery. And when it comes to calculating this exact quantum, I was wondering whether our focus on the breaches, on the damage caused by the breaches of international law during slave trade was really the only approach that we could take, because I felt that we could also perhaps draw from the Marxist concept of original accumulation of capital. And the reason why I'm saying this is that we live in a capitalist society. And in a capitalist society, it's very difficult to be a player when you don't have original capital. If you don't have, in the beginning of the game, the capital that is needed in order to transform your resources into wealth and into more capital in order to play. And I believe that one of the obstacles to African countries and Caribbean and Pacific countries to development is having access to this original capital. But we should think at the moment when Europe launched its development, it was able to get this free access to capital, in part through by commodifying and chattelizing Africans during colonialism, and then by exploiting their lands and resources, chattelization and commodification during the slavery, and then exploitation of the lands and natural resources during colonialism. So the question then becomes whether instead of thinking of calculating the amount of compensation to be paid based on the breaches of international law in the 19th century, the question does not become how can we make sure that the descendant of people who were formerly enslaved get access to original capital. How do we make sure that they get access to original capital in order to be able to prompt their development? But not only also the capital, because it's not just paying money and disappearing. It's also looking at the current system of international relations and removing all the hidden obstacle, the structural obstacle, if you take into the monetary and financial rules and all the other rules, economic rules, which are making it more difficult for those countries who have been under slavery and then colonization and then neo-colonialism to really engage freely in international development. It seems to be that this approach would be forward-looking, and it's the fact that it gives a result to be attained in terms of development is much, much better than just paying money and believing that it absolves all the breaches of international law that were occurring. But really, this is a recent idea that I've been thinking about, so I look forward to hearing your views. And I thank again the Brattle Group and the organizer for this stimulating report and discussion. Thank you very much.
I'm wondering if I should, I've been asked in the chat to go next, but I'm wondering if I should do that without the intervention of the moderator, or should I just go ahead? Because there was an error in the running order as listed and as stated before. So I've been asked to go next.
Yeah,
do I proceed?
yes, please go ahead, Professor Marshall. My apologies.
No problem, no problem. Okay, thank you very much. My intervention is intended to do two things. One, I want to acknowledge the very difficult task of the framers of this report in trying to, including those that are not presenting but listed as contributors to the report, in trying to come up with virtually a very difficult task of trying to estimate the cost of the damage and the cost of loss, and arising from enslavement, arising from genocide, as Sahiri indicated, genocide that was also part of that experience. And certainly from the Caribbean region's vantage point, this story also includes attempts at native genocide of the indigenous people. So we do have that element also to consider when we are looking to estimate the extent to which there has been a near impossible calculus around the kind of harms done to Caribbean people and their descendants, including, of course, as I indicated earlier, descendants of indigenous peoples. And they want to also include in that group Maroon communities in Jamaica especially. So I want to applaud the effort to come up with a quantification where some of us may be philosophically wrestling with the idea that some things cannot really be reduced to monetary values. I am one that's wrestling with that, but not in a way that suggests that there's closure around efforts and scholarship to bring about a quantification matched with an idea that the reparatory justice process really ought to be understood as one that goes beyond current models of intervention that speaks of aid, donor assistance, and other forms of providing capital, materials, or technical assistance to countries, regions, families that have been affected by this historical wrong. So I should say that philosophically, I want to indicate that from the way I see it, the challenge really we have is the kind of grammar we will employ for claims making, for the claims making that is part and parcel of the reparatory justice struggle, indeed the reparations endeavor, that an appeal that goes beyond that Caribbean people have been engaging. It connects up with what the brother who just spoke about when he speaks of global Africa's appeal for reparations. So my concern, my intervention really is about the grammar we employ, the way in which we speak about cost, damage, loss, etc. And I want to say that there are dangers inherent in trying to reduce this to, and I'm not accusing the framers of the report of doing so, but you know, the more you sort of a quandary in epistemology, or a quandary that develops when you try to produce a source of information and knowledge rooted in trying to come up with a positivist calculus of measurable objective damages, while seeking to acknowledge that it really is difficult because a lot of the damage is incalculable. So that one of the moderator of this morning's session would have indicated that, and throughout the challenge, you want to know how we would quantify psychological loss, psychological damage, sorry, because that's really difficult to quantify. So the framers of the reports are doing brilliant work, and it's governed by an intention that we must really calculate the cost of the weight of the loss. I would prefer to frame it. The weight of the loss, the weight of the damages, the weight of this historical wrong. And if we had to steer or lever the discussion away from just talking about monetary values and to talk about building and bridging a process of reparatory justice, of which an estimation of the harms is part and parcel of what we talk about when we're talking about reparatory justice. If we talk about trying to come up with an estimate of the harms, then it paves the way morally, ethically, epistemologically to speak about ways in which we undertake repair and renewal. Because once you've established that there were harms, and from the best efforts at quantifying such, we come up with X figure, Y figure, as brilliantly postulated by the framers of the report and those that spoke to that report today. I think it paves the way for us to then say, look, building and bridging a process of reparatory justice means we come to grips with the costs associated. We come to grips with the need for justice and accountability for the unremedied and unprecedented wrongs against humanity and every relation for sustainable being and becoming in life. Justice cannot be secured, we would argue, if the moral and spiritual debt is elided and redress overlooked. So when I look at the report, I see an estimate of the harms and a scope and optics for addressing the need for redress. So, so I would say that repair ought to be seen as an ethical project entailing the healing of relations and the status of the parties. And we want to also add and suggest that even as we come up with a quantum of what these harms have cost the regions and peoples affected, we start off with a philosophical position that the violators cannot redress the weight of the loss, and that the estimation of harms provides only a moral reckoning towards needs produced in the context of injustice. So because of the injustice accumulated, sedimented, carried forward, the needs produce, the harms will produce needs in the context of injustice. And it's the descendants that continue to bear the brunt of the injustice. So reparations then in that sense is about addressing and redressing the needs of the descendants of these people for whom crimes were committed, for whom genocide and attempts at near genocide were committed, and for whom their humanity was denied through enslavement, etc. So we're talking about a reckoning that ought to be addressed with in tangible ways. And it's those that suffered the harm that have to estimate what that cost will entail. And I think it's important that we make the point that it's, we need to listen to those who carry and live the legacies of race and harm, the legacies of racialized wealth and exchange. And that if we're talking renewal, if we're talking, and I'm saying if we're talking socio-ecological and economic renewal of Caribbean countries, for example, in light of the harms that were caused to the people, the biodiversity, the ecological harm, if we start to do an estimate of all the harms caused, say, to the Caribbean as a region within the Americas, then we're beginning to talk about the need for redress and repair. And these figures then become very, very relevant when we have shifted the grammar of claims making away from one that says you owe me X based on a calculus of damage and loss, you owe me X, to one which says you are ethically driven and bounded by the need to address reparatory justice as an urgent need. And that reparatory justice will include looking at an estimate of the harms associated with human degradation and suffering, the socio-ecological and economic degradation of these regions, and indeed, all this has to be steered along a plane that says repair and renewal is what reparatory justice should look like in public. Reparatory justice and how it will look like in private will take the form of the apologies, will take the form of building bridges, people-to-people bridges, but with African countries, West Africa particularly. There are also psychological repair that Rastafari, indigenous people, and others make that speaks to what reparatory justice should look like for every person. And it should involve re-engagement with lands, re-engagement with Mother Africa, et cetera, et cetera. But what reparatory justice should look like in public should take the form of recompense in the direction of repair and renewal of these economies and these societies and descendants who find themselves structurally structurally poor, structurally suffering from the loss of not having intergenerational wealth, et cetera, et cetera. So the watchwords for me is about repair and renewal, and especially exciting is the quantum leap made in attempts to cost and estimate what those harms entailed, while humbly suggesting these figures, no matter how much trillions, cannot really be seen as representative of the kinds of psychological damages that continue to be inflicted on people of color, and on the fact that they find it so structurally locked out because their life chances are overdetermined by race and color, and how that works in a world order dominated by white supremacist logics. I will cede at this point, yield at this point, sorry.
You're still muted, Adrian.
Can you hear me now?
Yes, we can.
Okay, sorry about that. Chantal, I'll assume that I just should start as happened with our last speaker. First of all, I'm very, very delighted to thank all of the organizers for this event, especially His Excellency Judge Robinson and his incredible leadership. Thanks also to ASIL President Gregory Schaefer, addressed us this morning, and staffer Wes Rist, who just intervened at this moment when I was still in mute. I'd also like to thank the University of West Indies and Professor Vereen Shepard. I actually wish this event was live there. In Iowa right now, it's below freezing, and I have enjoyed my visits to your campus. And of course, we have the very hardworking organizers, Natalie Reed and Professor Chantal Thomas. And I'm, of course, delighted to be joined by my co-panelists, Professor Mamadou Hebier and Professor Don Marshall. Also speaking today as the co-founder and former co-chair of BASIL, Blacks of ASIL. As I hope many of you know, BASIL was started in 2014, and it has had a rich history of involvement in ASIL activities. And my fellow BASIL co-founder, the Honorable Gabrielle Kirk McDonald, who was also an honorary president of ASIL, and also, as I'm sure everyone knows, a former president of ICTY. Her spirit is here with us. I don't know if she's online or not. So BASIL is very pleased to be involved with this event. And I enjoyed being involved in the 2021 conference, where I had the pleasure of introducing Sir Hilary, who this morning gave us some very profound comments. I relate very personally to this topic of reparations as the descendant of slaves in the United States. On the other hand, I realize my own privilege as I am a tenured chaired professor at the University of Iowa, and I've been here for 36 years, and I am a third generation college graduate. Yet, as the statistics have presented, my group, African Americans, remains disproportionately lacking wealth, in large part due not only to what happened during the slavery period, but of course the subsequent subjugation that the report definitely highlights. My 7 children and my 19 grandchildren face racism every day in the United States. It hasn't stopped. My partner, James Somerville, who is 65 years old and a dark-skinned African-American, has faced even more discrimination than I have as a light-skinned African-American, and we face this every day. I also have family from the Caribbean.
Adrian, you were muted again for some reason. I don't know what happened.
Okay, did you hear me mention James?
Yes, you were just saying you have family from, and then you got cut off.
Okay, good. I don't know why it did that, but I have family from the Caribbean as well as from Africa. I have indigenous roots, and also I have white ancestry. The nearest white relative to our knowledge is my great-great-grandfather. So I represent a melange of people that is very typical of many, many African Americans. Also, I was formerly involved with the National Conference of Black Lawyers for many years, and we were deeply involved in issues of reparations, working with groups like NCOBRA and others. And it is a shame that 40 years after my own personal involvement, that we are still discussing these issues. On the other hand, we know we're discussing issues that have occurred over 400 years. So we're actually making progress, that we are at this point where Brattle has produced an incredible draft trying to quantify the unquantifiable. So what I'm going to focus on is intersectionality. As Chantal Thomas said when she introduced me, I am the editor of two readers, one called Critical Race Feminism, and the other is Global Critical Race Feminism. Both of them involve the status of women of color, whether they be in the United States or in other countries. The report doesn't mention this, but Professor Kimberly Crenshaw of UCLA and Columbia Law Schools is well known globally for bringing this intersectional commentary into the legal academy and the writing therein. And so I was delighted to see the report actually had several references, intersectionality, and you often don't get reports at all that even comment on that. But I'm always pushing more. So for instance, I was glad to see a subsection of that has to do with the gender-based violence, and I appreciated the presentation where there was an attempt to quantify the gender-based violence. But there's a way that we can try to push it in further. And it's not an additive process, but in my writing, I call it a multiplicative process. So you have to look at not, plus female, and then a few things happen to those females, but the multiplier effect of having to look at not only race, not only gender, but also color, pregnancy status, parent status, marital status, age, class, and other health statuses, all will be intersecting, affecting the women that we are concerned with in particular. And of course, we know in many cases they were not permitted to keep their children, families were separated, etc. I was interested to hear of in the Caribbean when they needed to increase the population and couldn't get fresh slaves, that some places did some incentives to try to increase the population. And in the US, we all know example of the slave owners raping many of their female slaves as a means of increasing the population, along with them forcing sex between the slaves. So I'm not sure of the answers, but somehow this needs to be fleshed out, because when I looked at the number of the amount listed for sexual violence, I thought it was actually a bit low in these large numbers. And then I think somewhere it says there's maybe 58% of the women may have been sexually assaulted. And I don't know where that number would really come from, but why wouldn't we presume 100% of the people are sexually assaulted? And I said the people, because we can't forget the other side of the gender issue, that there are countless incidents where men were also sexually assaulted. And yet a lot of that gets suppressed. And then there also could be examples of homosexuality among the slave owners and whatever they might have felt they could get away with respect to their male slaves. And so we need to note or have something that the sexual violence can also be directed, as it can be now, to men. There's also something about children over 15 and assaults, etc. And we know children under 15 can be assaulted as well. And of course, in earlier eras, even in a society where there any of this violence, you might have sexual activity or marriages occurring with children much younger than 15. And so there would be a need to deal with younger, maybe perhaps younger ages than had been considered here. Another concept, my second concept I wanted to focus on briefly, is the non-quantifiable, which I have called in my own work spirit injury, that emotional and spiritual side of injury, which, although it's hard to quantify, there are occasions where it can be. And so in US law, for instance, you have the concept of intentional infliction of emotional distress. And they will quantify that. Maybe not enough, but perhaps there is some way to work out numbers for this kind of a era. You know, and when you imagine the multiplicity of loss, when you have lost your family, participation in your community, in your clan or your ethnic group, in your religion, right, being ripped out of their religions, their customs, the languages, food, the music, the clothing, the education, the wealth, the status, all of that, in one sense, could be looked at as unquantifiable, but perhaps we need to think about ways where we could quantify at least part of that. We have to at least try, I think, but even if we come up with a number, let's say it's, I don't know, 100 trillion or 200 trillion, of course, our next step is who could we get, what entities, what governments can we get to pay even fractions of this amount? And of course, even more, who do they pay it to? Do you pay it to the whole government of a country, to non-governmental organizations, or some other type of entity to try to figure out what to do with for sum of money it is, and what do we do about the blowback that will no doubt be in many countries? People will say, well, this person wasn't a slave, she's, you know, a fancy law professor. Why would she or people like her get any money? And if it goes to a group, well, you know, is it misused? So all of those critiques of reparations that are out there, we would have to deal. And even say, well, a government should owe it. I was involved with South Africa and the constitution making process there. And so, as you know, they had Truth and Reconciliation Commission, and there was a little part that's reparations. Well, the government, the post-apartheid government of South Africa, didn't have the money to pay all of the Black people who had had land stripped from them and their ancestors by the prior white government. So, you know, holding a government liable if it's a poor country, it's not going to work. But all of us enjoy going to London and Paris and experiencing all the riches that those countries have had, a lot of it based on the backs of our ancestors. So in closing, I just want to say this is a wonderful start, and I look forward to seeing the later drafts and also to participating in the rest of this symposium tomorrow. So thank you.
Thank you so much, Adrian, and thanks to all of the speakers. My apology for the error in introducing you. I'm sorry to have added that element of confusion and distracted from what has been a brilliant series of presentations. Thank you all for truly insightful remarks and for continuing this dialogue. We do have a few moments that remain, and I would like to ask each of the speakers whether you would like to expand on any of your earlier remarks, or in particular, if you'd like to pose any questions to the other speakers based on the other presentations. So I'd just like to open the floor now. Adrian.
I agree with what Professor Ebiye said, that you know, looking in depth at the situation in Africa today is quite critical. And I don't know if that can be added to this project or a totally separate project. And of course, the African Union and others may need to be more involved. But clearly, that part of it, I would love to see this kind of quantification begin to be attempted. And maybe it's already out there and I just haven't seen it yet. So if any of you know, or anybody listening, I'd like to know if there is something like that out there.
Mamadou, would you want to speak to that? I was also very interested in that element of your remarks. Today we speak about human capital, and one could think about the loss of human capital in terms of the depopulation of African territories as one potential element of quantification of damage. I think there immediately, I also think about possible objections that might be raised in terms of shared responsibility. We sometimes hear about, you know, sometimes as a sort of a politicized distraction from conversations around reparations, claims of shared responsibility for transatlantic chattel slave trade across European and African territories. But I think in general that is such a fascinating question. So I'd love to hear as well any other remarks you might have. I also see that Judge Robinson has raised a hand and would like to ask a question. So perhaps we could also hear from Judge Robinson and then see if we have some time for any additional remarks. Judge Robinson? You have the floor, Judge Robinson. I see that you're unmuted, but I don't think we're getting any audio. Having difficulty. Okay, so maybe I can turn the floor for the moment back to Mamadou if you wanted to respond to the previous line of questioning.
I think that the African part of the report would be interesting. It would be definitely fascinating. And I also agree with Adrian that the AU should take leadership in that respect. I don't believe that the claims that African countries were, or African people were complicit in the enslavement. It was really an entire dynamic. If you look at the beginning of the slavery and the slave trade, you had African polities, kingdoms fighting against it. But the slave traders managed to disrupt the traditional structures and to engage in new dynamic, which allowed the trade to last for a number of years, centuries actually. So I don't think that this will be a major obstacle. I agree with you that we could think about the loss of human capital, but it's not only that. You have to realize that slave trade, by extinguishing all the entities which were trying to constitute themselves as states and empire, created a gap of political organization, which facilitated colonialism in the 18th and the 19th century. And even today, when you look, for instance, at areas such as Mali, Burkina Faso, Niger, which were the areas where people run from the coast and slave traders in order to go interland. These are again the same areas where you struggle to have a strong political organization, where you have jihadi groups and entering as almost at will. So it is a phenomenon that had strong disrupting consequences in the entire. So again, another anecdote that I can tell you. Even now in Burkina Faso, we have an expression in Jula language, which is a language which is spoken in Burkina Faso, in Mali, in Niger, in Senegal, in Guinea, in Cote d'Ivoire, in almost all West Africa. It's the most spoken language in West Africa. And we still have an expression, and I will say it in Jula, Niakembi Feri, which is to say, if you do, I will sell you. You see, it is still there. It is still there, saying, oh, this idea that we could be selling each other is still there. And this lack of trust, this lack of confidence cannot allow strong political organization, a strong economy. No one wants to trust the other. And all this has to find its roots in the slave experience. So how will you be able to erase all this traumatic past? How will you be able to find ways to compensate for it? I don't necessarily believe that we have to try to identify breaches of international law and establish a duty to compensate. What I really proposed here is to say, you found your original capital to develop here. Now you are developed, and we are happy about it. It's good. Now bring back the original capital, so that we could also pursue development. It's true our destinies have been disrupted for 3, 4, 5 centuries, but now we have the opportunity to write a different story, and you can contribute to it because you benefited from it. And of course, even if you don't pay the money, at least show goodwill, show good effort, by removing all the hidden shackles in the international economy, which is still keeping African countries poor and excluded.
We could continue this conversation, I think, for many hours, if not days, but luckily the conversation will continue. We'll reconvene tomorrow. I believe that we must close the session in order to keep to time. Perhaps I'll just give an opportunity for any closing remarks or final observations from the speakers.
Yeah, thank you.
Yes, go ahead.
Yes, thank you very much. I do believe that there is the possibility of several kinds of emancipatory projects, reparations projects that could be undertaken simultaneously. I do think that the work to bring West Africa squarely into the picture is urgent work. It's urgent epistemologically speaking, even because the basis upon which we can understand each other and shape and control narratives is a critical first step to winning hearts and minds. So there is a prevailing perception of collusion, culpability, and so on that has been established not by anecdotes or fables, but that has been established through the venerable writings within Eurocentric circles and universities and so on. And there's a way in which that has to be addressed head on. We must have the engagement. We must have a confrontation with those kinds of narratives deliberately so that we can truly identify, there may have been complicit leaders and regimes, but that does not speak for the continent. It does not speak for whole countries. It does not speak for the resistance from below civil society across West Africa, in abject outrage against being traumatized and re-traumatized with the threat of being sent, as the brother just spoke, being sent to, So we need to know more if we're to understand ourselves and how racialized systems of wealth and advantage become consecrated as a common sense force in our lives, right?
Well said. We've heard about so many different aspects from epistemological, to moral, the philosophical, as well as the institutional, the legal, the economic, the empirical. So it really has been a very rich set of interventions in this session. And we encourage everyone to join us tomorrow for the continuation of this symposium. The session tomorrow will be convening at 10 a.m. Eastern time and Jamaica time. And you can refer to the website asl.org/events/reparations for more details. Thank you again to the speakers. Thank you to Judge Robinson, to Sir Hilary Beckles, to Greg Schaefer, to Dr. Vereen Shepherd. Thanks to all of you. And I will bid you goodbye for today.